Good evening, everyone. And amongst us, we have Justice Roshan Dalvi, a former judge from Bombay High Court. And as usual, we all look forward for the knowledge sharing. And we have always seen that her sessions have always been well received. And in fact, someone said that it's quite a long time that when Justice Roshan Dalvi has not shared her knowledge. And in one of the marriages, I was sharing that we will be talking about the topic on distinctions between a joint ownership and a co-ownership in property matters. And he's a quite seasoned lawyer, and he said, "Is it so, Mr. Vikas? Is there any distinction, or you are just joking it inside?" I said, "No, you will have to join the session." He said, "Okay, I will join it on the YouTube. I'd share a specific link with him." So be that as it may, since we all know that it's a weekend, but of late we are doing primarily our sessions on the weekends. So we'll ask ma'am to share her knowledge. Over to you, ma'am.
Good evening, Vikas
Ma'am.
and friends. You see, this topic is one of the topics which has not caused much controversy, and that is why someone in the wedding told you, Vikas, about whether there is any distinction or not. That's a very good sort of information that we have, that people don't know that there is any distinction, and there need not be. But in law there is, and we have come by way of practice in many of the things into essentially and only co-ownership. Now you see, properties are of two types, as we all know, immovable and movable. And the law of joint ownership and co-ownership would apply equally to both, actually. For example, if we have a bank account in two names, husband and wife, or two brothers, or whatever, or father and son, it's a joint account, we say, correct? It's a joint account. But if we have an immovable property, let us say a bungalow or a flat, we may not say it is a joint property, we say we are co-owners. These are the usual expressions. Now, how did these expressions come about? We must understand first a little history. Our laws are derived from the common law of England. Then we have had statutes just as they have had in England. Common law is the law of justice, equity, and good conscience. So whatever at the relevant time would be the ongoing just practice would be by way of precedence determined as law. Now in England, there were neighbors, there were friends who would buy immovable property together. We don't have that concept in India because we all the time take our properties, invest in properties exclusively for our families, not even for our close friends. So we have to understand this law as a distinction from the English law from which it developed. Now, joint ownership in England was that if two persons own a property, let us say a field which they are tilling, they are neighbors, they have two cottages side by side, and they are, as agriculturists, they have a plot of land. What happens is that they are joint owners unless they say that they are co-owners, and as joint owners, the property would survive to the other party when one joint owner dies. Now, therefore, if A and B own a property, when A dies, B gets the entire of the property. A's heirs and legal representatives cannot claim a share. If and only if A had a property in his single name, it would devolve upon the heirs as his separate exclusive property. Now, this provision in law is not so strange in India. We had the HUFs. We still have HUFs, Joint Hindu or Joint Undivided Hindu Undivided Family. This applies to the majority community of our country, and therefore we generally take this as the law of the land. And that is how the law has developed even for others. Unrestricted by the others, I would say. Now, when you have an HUF, you have co-parceners in the property. Until 2005, these co-parceners were only male survivors. So you had a propositus and his sons, 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 and sons, sons, sons. In this 3 generations after the propositors would constitute one HUF. In that HUF, now of course we have the daughters also being co-parceners. So it won't be the sons, 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 and sons, sons, sons. It would be the children, children's children, and children's children's children. And all of them would be co-parceners in an HUF property. This is the property that devolves upon you by survivorship, and it goes on for 3 generations after the propositors. Now, when it devolves upon a person by survivorship means that as soon as one person is born into that HUF, the shares of all other co-parceners would to that extent diminish. And when one person of the HUF dies, similarly, the shares of all others will augment. So they survive the deceased co-parcener, and they don't get the property by succession. This is what was the Hindu uncodified law prior to 1956, when we had the Hindu code. Now in 1950, after the coming of the constitution, and after an era ushering in gender equality, we had what was called the Hindu code or the Great Hindu Code. So we had the Hindu Marriage Act, the HAMA, that is the Hindu Adoption and Guardianship Act, the Adoption and Maintenance Act, the Hindu Minority and Guardianship Act, and the Hindu Succession Act. The first was of 1955, the remainder 3 were of 1956. Now in this, aside from other codifications, the codification always took into account the gender perspective, because women did not have absolutely any share, any say, anything in any of these 4 aspects. Marriages were not permitted, and therefore the Hindu woman had to remain like that, and there was no widow remarriage, etc. Then in adoption, a Hindu woman could not adopt, only the man could adopt, and when she adopted, it was only after her husband died and only for his funeral rites and ceremonies. In the succession, a woman never got the equal share of her predecessor in title, whom she succeeded. Now, they were all joint Hindu families or Hindu undivided families, HUF. And therefore, in 1937, we got the law called the Hindu Women's Right to Property Act, in which she got the share which her husband had in the HUF. This got diminished and repealed by the Hindu Succession Act, Section 14. We are not dealing with gender rights now, and we are not dealing with those successions, but a wife got succeeded to the estate of her husband, and that estate did not only survive upon her. So the HUF properties in which her husband had some share would devolve upon her by succession and not by survivorship. This was Section 6 of the Hindu Succession Act of 1956. It has been repealed by another Section 6 in 2005, when the co-parcenary law came to be completely changed. There was a quantum leap, and all the daughters also became co-parceners. But there was a succession, and that succession was very minimal before. So under the Hindu Succession Act, when a man died, his self-acquired property, which was taken separately, devolved upon his wife his children, and his mother in equal shares. When the woman died, her property devolved upon her husband and children in equal shares, but not her mother. This is the distinction between section 8 and sections 15 and 16. Again, we will not go deep into that. Our subject today is co-ownership or joint ownership. Now, under section 19 of the Hindu Succession Act, the mode of succession of two or more heirs, I'm reading the section, if two or more heirs succeed together to the property of an intestate, they shall take the property per capita and as tenants in common, not as joint tenants. We are concerned with the last aspect in this lecture. This was the beginning. Now, what are tenants in common and what are joint tenants? Tenants in common in Black's Law Dictionary. A tenant in common is that he can possess the whole property, but with no right of survivorship. And therefore, it is deemed to be owned by himself or herself, of course. So that person does not get the property jointly such that it would survive to the other co-partner or to the other heir. But whatever the two or more persons got, they got as their own separate property. Now, this property could devolve again by succession upon their heirs. Succession is of two types, testate and intestate. The Succession Act deals with intestate succession, not testamentary succession. Testamentary succession is under the Indian Succession Act, which deals with wills, etc., of Hindus, of Parsis, of Jews, Christians, and other sects in India, not of Muslims. So far as Muslims are concerned, again, there is succession, and that is by way of inheritance, essentially under the Hindu law or the Muslim law of succession applicable to Sunni Muslims. So far as Shia Muslims are concerned, they are governed by the Hindu law by way of custom. So again, this section would apply, and this law in that sense would apply, subject to certain modifications which are set out in the law. Now, again, we come back to joint ownership and co-ownership. When the HUF has all male members only, it would still devolve by survivorship, so that all the members would get their shares augmented when one member dies. It survives to the other members. But under section 6 of the Hindu Succession Act, there came to be an exception. The first exception which recognized the gender perspective, that is the right of a woman. So when a man had anybody else who was a female relative claiming through him, then he would get by succession and not by survivorship. Now we know that in most of the families, there is someone at least claiming through a female heir. It may be the wife, it may be the daughter, it may be the mother. In all of these cases, whenever there was a female heir, the right of co-ownership, the right of joint ownership or survivorship became diluted. And they took by succession. And therefore, the share of a man in even an HUF would devolve by succession to his heirs, that is to his wife, his children, and his mother. It would not go to the other co-partners who may be his brother's children, his brother's grandchildren, whatever. Okay? So now we have the co-ownership principle settled into our statute. And that makes it different from the British law. So we don't see the British law at all after 1956. We see the Indian law. Now, so far as I told you right in the beginning, a bank account is concerned, FDRs are concerned, movable properties, what happens is if you own them together, you are deemed to be joint owners. They are called joint owners, I would say. And when you are joint owners, what happens is that the share advances to the other joint owner. So far as banks, so far as financial institutions who give out FDRs, etc., even life insurance policies, LIC, they are concerned. They are not concerned with your law of succession. They are not concerned with how many heirs you have. Each of these heirs would take per capita, which means that they would take equally, and they would take as tenants in common. But they are not concerned. They apply the joint law, the joint ownership. And therefore, when one person dies, the bank account can be used by the other person. So when there is a husband and a wife, or two brothers, or a father and son, or mother and son, who have joint bank accounts, and when the person, one of the owners dies, the other owner, joint owner, becomes the sole owner. Okay? That is not the law of succession. Therefore, when they become the sole owner, they would have to hold that property in trust for the estate. The estate would comprise of all the heirs who are entitled to get, if they are entitled to get under the will, as per the will, and if not, by intestate succession, under the Hindu Marriage Act or under any of the personal laws. Okay? So therefore, banks and FDR financial companies, they actually make you fill up a form when you are applying for a bank account or an FDR, and you have to tell them whether it will devolve, the joint owners will operate the account jointly, or they will operate the account by singly, and how it will devolve. First named holder or survivor, anyone or survivor would be the options. Okay. Now this becomes a contract. So under a contract, persons can contract out of any other relationship, and the contract would prevail. So therefore, when a person dies in a bank account, the bank will accept the second holder. This is called the doctrine of advancement. This doctrine is again imported from the English law. The share advances to the other holder, just as it survives to the other holder. Just as any co-parsoner in India would get it in an HUF. Okay? And ultimately, in the succession, because they would take as tenants in common or as joint tenants or as co-owners or as owners in common and not as joint owners, ultimately, this would have to be divided amongst the heirs. This principle has been applicable even for nominations. So when you nominate someone in a bank account, when you nominate someone in your insurance policy, in your GPF, why is that done? Whatever is the amount which is in that account or in the FDR will be handed over to the person who is nominated. So you can have a single account and make a nomination. You can have a joint account and make a nomination. If it is a joint account, after both the holders die, the nomination would take effect and the nominee would be considered as the heir by that party, by the LIC, by the bank, by the financial institution, etc. And again, that nominee will hold the share in trust for the estate. This principle has then been incorporated in Section 30 of the Cooperative Societies Act, so that in a cooperative housing society or in any other cooperative society, when you own plots of land also, you have to nominate someone. And the society will recognize only the nominee, not all the heirs, because the society doesn't want to get into all those disputes within the heirs, if any. Nevertheless, the nominee will be able to be a member, will be treated as a member, will have to pay maintenance, etc. as a member, but that nominee will not be able to transfer that share to a third party, to transfer the property to the third party. Only an owner can transfer under the Transfer of Property Act. only an owner can gift under the Transfer of Property Act. So all those 5 votes of transfer under the Transfer of Property Act cannot be resorted to. They will have to get the probate or the letters of administration from the court in any of the presidency towns, Madras, Calcutta, Bombay. In other towns, they will have to prove either the succession by intestate succession or by testamentary succession, which is by will. After that is done, all the heirs, 2 or more who are claiming, will claim as co-owners, and only the nominee will not get. All right. If it was joint ownership, it would just simplicity devolve upon the other person, or even the nominee if there was a nominee. I hope this is very clear. Fortunately, we don't have much problem with this in our country. And everyone accepts that things will devolve by co-ownership or as co-tenants or as co-owners. All right. Now, when they become co-owners, then they start using, enjoying, possessing the property. They get juridical possession of the entire property. So if there is a flat, if there is a bungalow, if there is a field, they will start using it together. And therefore, if they want a specified share, they will have to apply for partition. Got it? So this, just as there were partitions for HUF properties, where only male co-partners could ask for partition, and the female, even the wife, could not ask for partition, but could get a share if a male co-owner wanted partition. Now here, anyone can ask for partition. So when there are any of the owners, they can ask for partition thereafter. If they can live peacefully together as co-owners, they enjoy the entire of the property. Okay. So if there are 3 co-owners, let us say the mother, the wife, and the son, then they would claim together, and even the wife can apply for partition because she has got a separate share under Section 19, which is as tenants in common and not as joint tenants. Very clear under our statute. I have seen, friends, even now in my consultations, that even the Muslims want this to be their law. It is not their law as per the Muslim personal law, because there are sharers. Okay. Now, sharers have a specified share. So a wife, for example, has 1/4 of the share in the property of her husband as a sharer if there are no children, and 1/8 if there are children. Similarly, there are shares of various other people. This is also because in olden times, there were joint families. So they were not joint undivided families or joint Hindu families. They were joint Muslim families, but they were joint. And they till the land, or they owned the property, or whatever that they did. Even in the desert in Arabia, if they had any land, they would hold it together and they got only that share. But today, even amongst Muslims, Parsis, Christians, generally the property is owned as a separate property, and the brother's children or the cousin's children or somebody will not claim a share, though they may be sharers. Only if the Muslim personal law is to apply, they will claim the share. In which case, for one man, there would be many sharers, not only his wife and children, or not only his wife, children, and his mother, as in Hindu law, but there'll be many sharers. And similarly, his heirs will claim in the property of his brothers or sisters or anyone else. That is the Muslim personal law. But since, by way of kind of practice, when a man dies, in bank accounts, in FDRs, the contract would prevail. And therefore, if he has got a bank account or an FDR with his wife, then the wife would get that bank account to the exclusion of the other heirs, who would be sharers under the Muslim law. Now, so far as the Parsis and Christians are concerned, the law of succession is in the Indian Succession Act. And that law would prevail as to what would be the shares. Just as in the Hindu Succession Act, what would be the shares are laid down. If not, then there would be the common law of England, which would be applicable to them, because there is no other law other than that succession law determining the shares, not the law like Section 19 of the Hindu Succession Act, which specifically provides that they will get as tenants in common or as co-owners. They don't have. Therefore, when there is no law, then the common law applies. So it is not that the British law applies to these people. It is a common law of justice, equity, and good conscience which would apply, subject, of course, to the contract law. Because under the contract, if there is any contract with a bank or a financial institution, that contract would prevail. Okay. So this, friends, is the whole of the law of co-ownership and joint ownership. It is otherwise quite drab, and I don't know how to make it more interesting. But these are the fundamental principles. Thank you.
Thank you, ma'am. As usual, spot on. Though on the chat, we have not received any query so far, but on the WhatsApp, on the YouTube, there are. One is, can there be a joint tenant or a co-tenant in Pagdi system as joint owners or co-owners in an ownership?
No. Can there be a joint tenant or co-tenant in
Pagdi system as a joint owner or a co-owner in ownership?
This Pagdi system is actually an illegality. You cannot take a Pagdi. Pagdi is black money which the landlord takes from his tenants when the tenants want to transfer the property. So he would say that I will get 1/3 of it. Now, that was the position until 1999. And these laws are more or less the same in all states, but it's a state law. And formerly we had the Bombay Rent Act. Now we have the Maharashtra Rent Control Act. Under the Maharashtra Rent Control Act, he can take a premium and he can have a separate contract. So it is not that under the Pagdi, so when a tenant dies, you would have either joint tenants or co-tenants. The Rent Act would have applied, the Bombay Rent Act would have applied, and the person living with the deceased at the time of the death of the deceased becomes a tenant. Because that is a separate law.
This is, can society make the eldest son or the first name holder?
Can society
make the eldest son or first name holder in a shared certificate as member of the society without taking any NOC from the other members?
No, there is nothing like first name holder or anything. That is the doctrine of primogeniture, which is not applicable to Indians today. We had this primogeniture in trusts and all that in the earlier times. But the societies must insist on and do insist on nominations. Because under Section 30, you have to nominate someone. He may not be your first born son or anything like that. You can nominate anyone. You can nominate even your friend. And the society will only transfer the membership to the nominee. That's all. The nominee can get into possession but cannot get all ownership rights. The nominee will hold it in trust for the estate.
This is 3 questions have been posted on the WhatsApp chat. No, on the Zoom chat.
Yes.
First is whether live interest holder and interested and vested minder can file a suit for partition against another life interest holder and a vested reminder.
See, life interest holder, you mean if there are 2 life interest holders, they would get not a life interest in an intestate devolution. That is done away with. Only the women had a life interest under the Hindu Women's Right to Property Act. This has been done away under Section 14 of the Hindu Succession Act, so that if she is in possession of any part of any property, she takes that as a complete owner under Section 14 and she gets it. But if there is a life interest created under a will or a trust deed, then that life interest would prevail over whatever is the other interest which could be created. So if you have, say, my wife will use it for her lifetime, and after that, 2 out of my 3 sons will become the owners, then that would be allowed and applicable if it is in a trust or in a will. For a person who has died intestate, there is no question of such life interest. The property always devolves by succession under Section 8 of the Hindu Succession Act for males or 15 and 16 for females.
Nancy, she says, ma'am, there is a pagadi system still prevalent in Mumbai in the old heritage structures building in Kolaba. If resident of the flats want to transfer.
Yes, that is the practice. But that practice is an illegal practice. It cannot be done. The thing is, when a tenant wants to transfer the property, the landlord can say, I will not make the transfer in the name of a third party at all. I refuse. Because now, under the Maharashtra Rent Control Act, the landlord would say that your entire tenancy comes to an end if you want to transfer. If you transferred it, you created a sub-tenancy or anything else. It's not recognizable. The landlord will only recognize the tenant living with the deceased at the time of the death of that tenant. And he will have to make them a tenant, of course. That also actually in these old premises, the landlords don't do. And the rent receipts continue to be in the name of the old tenant, sometimes the grandfather, grandmother, like that. But that is not the law. That is the practice.
This is Sangeeta. She says, ma'am, as far as insurance nomination, the 2015 amendment of the Insurance Act made the nominee having full right on the claim of money, excluding other heirs in terms of Section 39, subclause 7 of the Insurance Act.
Of which act?
Insurance Act.
Under the Insurance Act, under Section 39, there has to be a nomination to be made. Now, you may have 5 heirs. You cannot nominate all 5 heirs. The insurance company would insist that you nominate anyone. So you can nominate any one heir. The insurance company will give the entire policy maturity value to that nominee and get out of the fray. This is so that the insurance company is not involved in unnecessary litigation between heirs who are contesting parties in a suit, in a civil suit. But that nominee will again hold that property in trust for the estate. So the nominee will take the money, but the nominee cannot throw away all the money and blow it up. And if the nominee blows it up also, if there are 5 heirs, and if the other heirs claim their share, he will have to pay that share to the other heirs out of his own pocket. That is Section 39. It is equal to the same as Section 30 of the Cooperative Societies Act, and it is like any of the practices under the contract with banks, etc., for any monies, because that is movable property.
This is, madam, if a daughter gets a share in the property as a co-partner,
yes.
Section 6,
yes.
whether her heirs will get co-partnery rights in the said property, or will it be a separate, individual separate property?
No, that, yes, the daughter would get only the share in an HUF property, not in a self-acquired property as such. Now, when she becomes a co-parsoner under Section 6 of the Hindu Succession Act of 2005, from that 9th September 2005, then she becomes a co-parsoner. Therefore, when she dies, her share will survive to the other co-parsoners. All the other co-parsoners. So her heirs may be the co-parsoners. If she has got her own children, and if there is the propositors and 3 generations, they would become co-parsoners. And that is only in the HUF property, not in separate self-acquired property.
So thank you to all those participants who have been watching us live on the Facebook, YouTube, and also on the Zoom meeting. Stay connected with us, and you can share your any topic which you like or with the speaker. We will request them to take forward. And thank you. Namaskar. And on Sunday, we will connect on the partition in the revenue in the agricultural lands by Justice Paramjit Singh Dhaliwal at 6 p.m. So do stay.